to the 284th Legal Empowerment Through Interaction Lecture Series. Today we got a wonderful topic. The topic being voice of the child versus parental rights. And very, very typical of Anil Malhotra, sir, we added one thing more, judgment reserved. Today we hear it from the master himself on the subject of the voice of the child, to what extent will be heard when it comes to parental rights or custody of the child. So without wasting any time, welcoming all of you to this wonderful platform, may I request the speaker, Anil Malhotra, sir, to please address us on the topic.
Thank you, Shyam. It's a very interesting topic that you have chosen. And I wish to say that this topic is prompted by a very recent judgment of the Calcutta High Court, dated the February 28, 2023, by Justice Soman Sen and Justice Uday Kumar in a matter called Sushmita Sarkar versus Pratik Ram Mondal, whereby the court has walked a new mile and has gone totally to decide where a 13-year-old should go. And the entire judgment is based on what is the true import of the best interest and welfare of the child. And I would call it that the judgment is actually the voice of the child. The honorable bench has exclusively relied on what the 13-year-old says. And in his words, he expresses to the court that he does not wish to stay with his mother, who is at work, and his grandparents who are old, who visit him sometimes. And he would like to go back to the family of his father and the extended family of his father, where he says that I find more comfort and I find more happiness. Now, this is best expressed by reading a paragraph of the judgment itself. I will first read out the paragraph, lay down the background for the discussion, and then we will move forward to explain what exactly the content is. But first, what does the judgment say? The court says the contention of the wife that the child was duly taken care of at her parental residence is completely belied by the fact of the candid statements of the child that sometimes during few weekends the maternal grandparents used to come by to give him company. But due to distance and old age, such visits were infrequent. The opposite party has admitted that when the child was suffering from certain ailments and she did not inform the father, she being alone, it was difficult for her to provide him the medical treatment. The child could not be turned into a virtual recluse, as it would cause psychological harm and mental disorder to him. He will have an unhappy upbringing, and it is the responsibility of both parents to take good care of him. The evidence on behalf of the parties overwhelmingly shows that in his house, that is the father of the child, he had all the facilities which would enable him to grow into a proper human being. The child has admitted in his brief interaction with us that he was extremely happy with his parents, but he was more happier with the father. And he did not complain of any rude behavior of his father. The appellant could not establish even prima facie that the applicant father or his family members were in any way unsympathetic, insensitive, or irresponsible. Now, they say that the conduct and behavior of the respondent does not inspire the confidence of the court that the child would receive adequate comfort, care, and love and place in his mother's house. So the court goes on to say the child did not get the warmth and caring of his maternal grandparents due to their unavailability. There is also evidence to show that the child was not taken care of. On our interaction with the child, he clearly expressed his happiness to be with his father. Now, the court has been persuaded exclusively by the view of the child, and in this perspective, the custody has gone to the father, and the mother has been given twice a month visitation with the access to the child and regular telephonic contact, and the coitus was put an end to. So, listeners, uh, colleagues, and honorable people on the bench and the bar who are hearing this webinar, the Hindu Minority and Guardianship Act, as the umbrella legislation, very clearly says in Section 6 that the custody of a child shall be with the father, that is the natural guardian, and after him the mother, and the custody normally of a child less than 5 years of age shall be with the mother. But courts have recently interpreted this to say that this is not a hard and fast rule, that a female child or a male child less than 5 years of age has to go to the mother. It can go to the father. And likewise, more than 5 years can go to the mother. So gender preference has been done away with, and both parents being natural guardians, the courts tend to lean in favor of the guardian in whose hands the best interest and welfare lies. Now, in this perspective, when we look at the Hindu Minority and Guardianship Act, Section 13 also talks that the welfare of the child will be a consideration which will be paramount. Now, coming to the Secular Guardian and Wards Act of 1890, there also the same position follows, that the natural guardian of the child shall be the father and the mother, and both being equal, the court is to be guided as per Section 17 as to what will be in the best interest in the welfare of the minor. But in Section 17(3) is the provision that if the minor is old enough to form an intelligent preference, then the court may consider that preference. So the preference of the child, indicating his welfare, indicating his best interest, can become paramount, as has happened in this judgment of the Calcutta High Court. But this has also happened in Neil Ratan Kundu's case in 2012, where the wishes of the child to be with the grandparents was preferred to the father, who had been accused of murdering the mother, and the child said, I wish to stay with my grandparents, and the courts leaned in favor of the grandparents and granted the custody to the child. Now, in this backdrop, whenever a family court exercising its jurisdiction under Section 7 in deciding a suit or proceeding in relation to the guardianship of the person or custody or access to the minor is to be guided either by the Guardian and Wards Act or the Hindu Minority and Guardianship Act, but the paramount underlying consideration being the welfare of the child. But the welfare of the child can be assessed, can be weighed, can be calculated by the court in its wisdom in a given case on the wishes of the child, where according to Section 17(3), if the child is old enough to form an intelligent preference, the court may consider the child. Now, this has a pinch of salt. Sometimes the child is polarized and alienated. If the child is spending a lot of time with one parent and has not been allowed contact with the other parent, the child gets polarized. The child gets alienated. The child fears that he will annoy the parent who is his present custodian, and so the child starts expressing negative feelings about the non-custodial parent just to keep the custodial parent happy. This is often seen when children have visitation or children have parenting time with the other parent. So the child expresses freely to the non-custodial parent. But when the custodial parent is present, the child behaves in an exactly opposite manner. So this, interpreted in Vivek Singh versus Romani Singh in 2017 by Justice Sikri in a very well-written judgment, has identified the concept of parental alienation syndrome, which has been seen in Navtej Singh's case to be a psychiatric disorder of the first degree, and it is to be treated by expert psychologists and trained mediators. And the only thing they advocate is that there should be free access to the child with both the parents, and this problem can therefore be got rid of. Now, the background of where all this has crept in, the best interest of the child, the wishes of the child, or what I call the voice of the child. This is arising from the Convention on the Rights of the Child, which was signed which was acceded to by India on 11th of December 1992. But before that, let me also share that in the Directive Principles of State Policy, under Article 39 of the Constitution, it is specifically said in 39F uh, that the state shall, in particular, direct its policy towards securing that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Now, this, of course, is only a mandate. It is not justiciable nor enforceable. So, what is justiciable? So, once India signed the Convention on the Rights of the Child in 1992, now the preamble to the UNCRC says the states parties to the present convention convinced that the family as the advancement group of society and the natural environment for the growth and well-being of its members, and in particular children, shall be afforded necessary protection and assistance to full responsibilities and in community. Then, recognizing that the child, for the full harmonious development of his or her personality, should grow up in a environment of a family and in an atmosphere of happiness, love, and understanding. Here I may pause to say I can never forget the quote of Justice Mridula Bhatkar interpreting the word family in a judgment to say family means father and mother, I love you. So that is the individual breakup of the word family. So that being apart, now the provision as far as the right of the child is concerned is, is found in Article 12 of the UNCRC, where it says state parties shall assure that the child who is capable of forming his or her own views, the right to express those views freely in all matters affecting the child, the views of the child being given due weightage in accordance with the age and maturity of the child. Article 12, subsection 2. For this purpose, the child shall in particular be provided an opportunity to be heard in any judicial and administrative proceeding affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. So, what is the mandate of the UNCRC? That the child must find a voice, the child must find a choice, and that choice must reach the court. One step towards this direction is the court taking assistance of mediators, conciliators, trained psychologists. But the Bandra Family Court Bandra in Mumbai has taken the very happy step of appointing a council called a child independent lawyer. So, depending on the experience and maturity of available counsels practicing in the court, the family court, the principal judge of the family court has made a panel with the approval of the High Court of counsels who are known as child independent lawyers. Means they don't hold a brief for either party, they hold a brief for the court, for the child, and is an equivalent of an amicus appointment. So they will be the representative of the child, they will further the views of the child, they will take the opinion of the child to the court. So these are modes and means by which we can administratively bring in the voice of the child, the view of the child, or the opinion of the child to the court and assist the court in coming to a conclusion as to what is the best interest of the child. Now, since we have not been able to make very many amendments, I think the flexibility comes in the Family Courts Act in devising its own procedure, because under sections 10, the CPC is allowed to be flexible. And it is said in section 10, subsection 3, nothing in this code shall prevent a family from laying down its own procedure with a view to arrive at a settlement in respect of any subject matter of suit of the proceeding as to ascertain the truth of the facts alleged by one party and denied by the other. Then in the Evidence Act application in section 14, it is said that the court can receive any document, statement, or information irrespective of the provisions of the Evidence Act. And then under section 12 of the Family Courts Act, the court is free in any suit or proceeding to secure the services of a medical expert or any person, whether related to the parties or not, including a person who's professionally engaged or monitoring the welfare of the family as the court may think fit for assisting the court in discharging its functions. So there is a lot of flexibility in the court resorting to any means or mode in ascertaining what is the best interest of the child. Now, this all is because of the uh, preamble of the Family Courts Act, which essentially says that the act is a means of promoting conciliation and securing speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith. So it is this flexibility in the Family Courts Act which is empowering the court to devise its own structure, its own formula in coming to the nitty-gritty of the matter. Now, this is the broad, so to say, evidential scheme which has been laid down. Now, from my experience in cases of child custody, what is often seen is that the pleadings talk more about the rights of the husband and the wife, the father and the mother, and very little of the child. This is the ugly position or the bad outcome of the singular custody concept in the statutory framework of the Guardian and Wards Act. Now, the Guardian and Wards Act of 1890, which is highly unsuited for today's circumstances, is aimed or is designed to prove who is a better parent for singular custody. The concept of joint custody or shared parenting is not in the Act. It is something which Justice A.P. Shah has pointed out in report number 257 of the Law Commission of India in 2015. But that amendment, that change in the Act, HMGA and GWA, has yet to come. So the set procedure among councils, among courts for adjudication, and among parents is to fight for custody and to prove why he or she is a better father or a mother. So in this process, there is a match, meaning the father and the mother try to outscore each other by flinging mud at each other. He's having a relationship. She is a bad mother because she beats him. The father is accused of negligence. The mother is accused of poisoning the child. So there is a flinging match and accusations left, right, and center are heard. And these are helped by different people involved in the drafting of the pleadings. So the effort is to fling as much mud as possible at each other so that you prove that you're a better parent. And in this process, the entire exercise, the entire effort of ascertaining the welfare of the child is lost. So very often when I'm an amicus in a habeas corpus for a return of a child to a foreign jurisdiction, there will be 2,000 pages of pleadings. There will be report of detectives. There will be reports of photographs or videos of where the man or the woman has gone in a hotel with somebody. There will be allegations of mental disorder. There will be allegations of adultery. There will be allegations of drug abuse. There will be all kinds of allegations. And the habeas corpus petition is actually converted into a divorce petition. If you come to think of it in the nitty-gritty, there is nothing about the child. I remember on one occasion a judge saying, I think none of you deserve the child. I'm sending the child to a boarding school. You both pay and you both visit the child in the boarding school. The child will be happier in a boarding school. So this is unfortunately the path of litigation which has prevailed in our courts. The lawyers very mechanically design these pleadings in a stereotyped way. Computer-aided technology helps in lifting material by search on the internet. And unfortunately, the court, with only what is said in the act before it, is pushed into deciding to whom to award the gold medal and to whom to award the bronze medal. So this unfortunate exercise ruins what I would say the welfare of the child. So this is what the topic is all about. Voice of the child versus parental rights. Is a custody petition, is a guardianship petition, is an appeal against the order of the family court to the high court a decision on what is the best interest of the child, or is it who is a better parent? We don't have to award a certificate that you're the better parent. Article 19 says that a parent to be deprived of the custody of the child has to be declared unfit. I think this act is absolutely outmoded and it has outlived its utility. We cannot talk of all these things in today's time. We have signed the UNCRC. We have to look at the best interest of the child. We have incorporated in section 2(9) of the Juvenile Justice Care and Protection of Children Act as to what is the best interest of the child. And I am always at pain to read the definition in section 2, subsection 9, because the best interest of the child is best defined in section 2, subsection 9 of the Juvenile Justice Care and Protection of Children Act. And it is a very wholesome definition, which I always quote in any child removal matter. Best interest of the child means the basis of any decision taken regarding the child to ensure fulfillment of his basic rights, his needs, identity, social well-being, development, and physical, emotional, and intellectual development. Now, this definition of the best interest of the child is nowhere pointing out or leading to awarding a honoris causa designation to a better parent. It is talking of the child. But where are we lost today in the conventional litigation which we conduct in our courts? We look at deciding who is the better interest of the child. So when I am in a matter before an honorable judge, if one parent has the custody, the other parent is looking for visitation. Is visitation the right word? You get visitation rights for a prisoner in jail. I think the phrase should be parenting time. And why should one parent hold a child to himself in captivity? Is the child an award or a prize to be given to a better parent? No. And in the bargain, you are ruining the mental health, the physical growth, and the development of the child. So this negative connotation in the conventional way in which we conduct this litigation has led to totally demolishing the best interest of the child. I was watching a matter in the online hearings of the Supreme Court yesterday. There was a case in which a mother had lost in the family court. The mother had also lost in the family court. Then the mother was in a for the Supreme Court. The matter was being heard by the first bench, and the Honorable CJI was at pains to point out to the lady appearing in person that you have a concurrent finding of fact in two courts. What is the point of law that you are agitating, which urges us to look into the matter? She says, you must hear me. So I must say that the Honorable CJI was very, very sympathetic to her, was very indulgent to her, and he knew that she could not understand what they were trying to say. They said, we cannot go into your facts. She says, no, the facts have been interpreted wrongly. The evidence has been misread. They said we cannot go into it. Two courts have decided, and it's a very detailed judgment of the High Court, and they have gone into every aspect of the matter, and we cannot disagree on facts. What is the point of law? So the opposite counsel on a caveator said that there is whatever has been said has not assumed finality, because child rights are never final, and she has been given an opportunity of coming back in a fresh petition if circumstances change. But she insisted. So the Honorable CJI told her that we can give you a legal aid counsel who will assist you in the matter, and he will guide you on making a presentation. She still insisted on arguing. I must say he was very, very sympathetic and very, very considerate to her. Hats off to the CJI for this. So he said, we will hear you. Why don't we give you a second time? They said, we will give you a counsel. You explain your case to me. She said, no, I insist on arguing in person. Even at that point, that the court did not lose its temper or say anything wrong. They said, all right, we will hear you, but not today, because the majority part of the day had been taken up by one singular matter relating to place for chambers for lawyers and other issues. So they said, we will hear you on Monday. So she said, no, Monday doesn't suit me. I want a time at 2 o'clock. They said, all right, Friday, 2 o'clock. I mean, this was the indulgence shown by the court. So this is a considerate court. But 9 times out of 10, what happens? Oh, child is with the mother. What's wrong? Oh, there is a father also. The father wants to meet the child. Getting a order for visitation of the child, getting a order for talk to the child on telephone has become an impossibility, because the custodial parent thinks that the child is a prized possession to be kept wholly in my custody and in my captivity. So invariably, sufferers I have seen are the fathers. They find it extremely difficult to talk to the child, and sometimes court insists that you must meet the child in the court. Now, the question that I ask myself, is the court flooded with lawyers, men in uniform, policemen in uniform, and a whole host of pharmacists? Is it a good place for a child to be meeting his parent? So the child will be overawed by the perplexity of the infrastructure and the people around him or her. Will the child behave normally? No. I have also seen judges where I have assisted as an amicus, the judge saying, why don't you take the child to a mall? Why don't you meet the child in a lobby of a nice hotel with a play side or near a swimming pool? So that is an intelligent way, I would think, of making a child comfortable. The non-custodial parent being in the vicinity, and the custodial parent coming in and handing over the child, and then the child spending quality time with both the parents. This, in fact, is the ideal situation which can happen. Now, the matter has acquired complex situations where, in two matters, the children have been removed, taken out, and flown to different countries. So this is a situation which is alarming and has created complications. So the child's passport being retained, the child not being taken out of the custody of the court, has become an important issue. But at the same time, let us not forget that joint or shared parenting is a concept which has been talked about freely in court citations. First of all, in Lahari Sakhamuri in 2019, the Supreme Court did away the concept of gender preference, and this was repeated by Justice Deepak Gupta and Yashita Sahu, where again the court said the fact that a child is of a particular age of age and should go to a mother or a father is not a concept. It can interchange depending on the best interest. Now, the concept of shared parenting and joint custody finds very good mention in Savita Sitaram 2020, Arobale 2016 Bombay, in Inderbir Singh Amandeep Ban's Punjab and Haryana High Court 2019, and then in Rajneesh Sharma versus Kamal Sharma. This is a division bench interim order where the High Court of Punjab and Haryana is looking at the government of India for saying what is their policy on shared parenting, what are they going to do about the Law Commission. So there is a step forward. Then is Aditi Bhakt versus Abhishek Ahuja Now, these are all cases where the court has gone on in devising a way or a method of Monday to Friday mother, Saturday, Sunday father, child going back. This can happen when the towns are in the vicinity or people are living in the same town. And this can flexibly be done, but with the approval of the court. So, but what do we really need? I think the immediate need of the hour is that in a given matter, the CGI, with his wisdom and his far-fetched experience, must devise some kind of guidelines or some practice directions or some mandate under Article 142, which will introduce the concept of shared parenting or joint custody, because it's only then that it will acquire the status of law made by the Supreme Court under 141. In the absence of any amendment to the statute coming in any way, this perhaps will be the only way in devising a way forward of breaking the uh, traditional conventional path of what is laid down in the Guardian and Wards Act and the Hindu Minority and Guardianship Act of single parenting. We have to, in today's time, demolish and judicially erase the concept of singular custody. I think singular custody is an antithesis to the welfare of the child and the best interest of the child. No child deserves to grow up with a single parent when the other parent is alive, expresses his best interest in welfare, and is willing to contribute. Why should you deprive another parent? Unless there is depravity, there is child abuse, or there is harm to the child. These are exceptions. So, in a society where a child is entitled to love, care, and affection of both parents, the Supreme Court ought to, in a given case, lay down some principles where joint parenting and shared custody should be tried. They should also lay down exceptions when it should not be tried. And that, I think, should become the mandate of law to go through into family courts, because we now have a regime of family courts practically all over the country. So there is a very dire need, like Vishakha laying down sexual harassment in workplaces and ultimately coming the legislation after 15 years. We need some light. We need a mandate. We need a judicial decision. We need a mandate under Article 141 for the courts to follow, so that the courts cannot turn around and say, I'm only doing what the act says. So therefore, what's wrong? So in this war, in this battle, and in this fight for the custody of the child not being a trophy, the child not being a winner, the parental rights ought to be left to be decided in a divorce petition, where again we are on a fault theory, which again needs to be re-looked at. So for the fault theory or the fault grounds to creep in into child custody litigation is an antithesis to the best welfare of the child. So more often than not, you find that the divorce petition and the child custody petition are a verbatim copy of each other. Easiest thing for a council to do, make one petition, copy paste, and just change the top and the bottom and give it a different nomenclature. So this has to go, and the court should heavily deprecate such practices. And I think it's time the family courts ought to say, I don't think your pleadings are in order. Because once you put in pleadings and the court coins issues, you go and you tread into a different path. So rather than treading a wrong path to reach a wrong end, find the right path to reach the right end. And I think that is where we need a changing of thought process. The litigation should talk about the child, not about the father or the mother, or how good he is or how bad she is, how rich he is, how financially secure he is, how educated he is, and what he can provide. It is not what he can provide. It is what is the child's requirement, the child's need. The court often says financial capability is no measure or a peg to decide what is the best interest. It's the child's needs. So with this new thought perspective, with this brand new ideology, I think Justice Ramakrishnan will decide how to pronounce the judgment. because he has been listening very intently. Over to you, sir.
Thank you, Mr. Malhotra. Really, it's a thought-provoking process because as it comes to the family courts, even the pleadings, what happens is who is the best parent to look after the child is a criteria to be taken into consideration by the lawyers when drafting the pleadings. And that weighs much for the purpose of finding out the best interest of the child also. Welfare, the dominant, because the Supreme Court in several cases has said, it is not the right of the parents to get the child, but predominance is the welfare of the child, which will be the best interest of the child to be looked into for the purpose of providing custody. And as you rightly said, the present act, whatever be the act, into Minority Guardianship Act as well as the Guardian and Wards Act, only provides up who is the best parent to whom the child will not be given, who is entitled for custody. So it is that on that background that the courts are also working for the purpose of finding out who will be the best person to look into it. But it will not be changed. See, one thing is there. Earlier, there was a joint family system. Yep. Even the concept of family itself has been reduced to father and mother, grandparents be left out. As yourself defined, when one of the courts said, parent with the family means father, mother, and child. Even in the school, what is being taught is what is a family? Means father, mother, and child. Even they don't require a brother or sister also. See, that is the way in which things are going on nowadays. That nurtures the child also about the concept of who has to be entitled one. Secondly, the children also brought up in a selfish manner. So they know now the psychology of the parent. Even when they are living together also, they know how to knock off their benefit, their needs. I underline your word needs of the child. They know with whom they will have to be. They are very, very intelligent nowadays. If they support the father, he will get whatever required from the father. He supports the mother, he will get whatever is required from the mother also. So there is even when they are living together also, there is a competition between the parents. How to get the best love of the child now. So that attitude must change. Both the parents must think that both are required for the... See, that concept is brought out from the beginning itself. That is taught from the beginning itself. I think that to some extent, the possibility of child being tutored or polarized, as you have said, can be avoided. Because the child knows, because now the children are intelligent. Very, very intelligent, because when you ask, they know who is the best father, who is the best mother, whom they want. That much, even if you ask the 6-year-old child, they may be able to analyze with whom they want to be. See, that was the intelligent level of the child. Probably we do not know from where they are getting the knowledge also for those purposes. Maybe what you call the IT gives you the power.
Artificial intelligence.
Artificial intelligence. That gives you that much power. So, and now only the Supreme Court also said joint parenting must be promoted instead of going for treating the child as a child, the chattel, with whom you will have to be given for some period and with whom other. So how far it is possible is a question. Even if the guidelines are provided, whether there is any possibility for father and mother living together for the sake of the child and looking after the child, you can't. Then only the joint parenting will come.
Absolutely.
See, they must get the opportunity to live with both. Otherwise, because recently I saw a film, Tada, I don't know how many of them have said this. It's a Tamil film where there was a marriage. After some time, what happened? The child begotten. There was some rift between the family. Mother, after delivery, left the child in the hospital and left. The father has no opportunity to take it, but he also feels that why should I? Then thereafter, he left it in the aftercare home. But on the way, he realized that what he was doing was wrong. So he went back and take back the child and brought it with a single parenting. But that was a film where he never said bad about the mother.
Oh, best
Never
thing.
said, but and the child was not asking anything about the mother. He was asking why you are not asking about the mother. Then the child was telling, if I ask, it will hurt you. So I don't want to hurt you because you are looking after me well.
What
So
maturity.
that way, and ultimately the film ends in a better way. After a long time, these people were meeting together. It ended in a divorce because then we're going for another alliance. But subsequently, when she saw the child, she got reverted back because the way in which she was brought up by the father, because the father was earlier, he was rude, very rude, and all habits were there, all vices were there for him. But subsequently, he changed himself for the child and brought up the child in an appreciable manner. Even he was not liked by the parents, his own parents. He was left out because of the character, in fact. But the child changed him. When he was living with the child, he thought that it is required for him to be, what do you call, change himself for the purpose of the child. And ultimately, the film ended with a theme that both parents are required for the child, and they join together. So
Excellent.
this is a way in which this also, because some films sometimes show some message depending upon the society's need nowadays.
Absolutely.
That is also required. So this is a way in which the people will have to be cultivated, and then whenever they go to the court, they should not think about themselves. They will have to think about the future of the child. Once they thought about it in a rightful manner, I don't think that they will mudsling each other. They will only think about the child. Even if they want to live separately for some period, thinking about the welfare of the child, they will keep the relationship intact.
Yes.
At least the marital status. Once the status was there for some time, there is a possibility of change. Nowadays, the whole difficulty is that such a circumstance or such a situation is not being developed even among the family now. So that society will have to change. Only if the society changes, all these things can come to a good for the welfare of the child. That will be better because the laws are there, conventions are there. How to incorporate in the law is a question. Once it is incorporated, also how it can be practicably put into action also is also there. Unless both help each other, I don't think this will be happen. But anyhow, it's a good thought process that will have to be looked into by the parents, fighting parents. I can say fighting parents nowadays for their interest, they take about the interest of the child and then forget and forgive. That policy must be there for the parents throughout. Then everything will change. Thank you very much.
Thank you, sir.
A very sensitive topic, beautifully presented by Anil Malhotra sir and wonderfully commented upon by Justice Ramushan sir. Vikas has put the hand up. Can I just, Vikas, can you unmute your hand icon is up?
Yeah. Good evening, sir. Thanks for opportunity. Sir, I have two questions. One is that can an interim application under section HMA 26 can be filed in divorce petition for shared parenting? And secondly, sir, our High Court has given a judgment in Neha versus Vibhor, where they disallowed husband and wife recording. And which is already challenged in Supreme Court, and where Supreme Court has given this stay on that case. But despite of that, family court in Punjab and Haryana not allowing this conversation. So what's your views, sir, on that?
See, first question which you said, can in section 26 you decide interim custody? Yes, you can, because section 26 is worded in such a way that it empowers the court to decide the question of custody. Section 26 is very clear in its wording, because section 26 says that in any proceeding under this act, so essentially there has to be a proceeding under the act, meaning divorce, restitution of conjugal rights, or judicial separation. The court may from time to time pass such orders and make such provisions as it deems fit, consistent with the education and wishes, whatever, to make interim orders regarding the child. So interim custody can be decided under section 26.
No, shared parenting, sir, under HM.
If you put forth a shared parenting plan by way of an application with proper details and you ask the court that during the pendency of the litigation, please give us a shared parenting plan, I'm sure the court can look into it. There is no bar in a shared parenting plan being looked at, because what is said is, in any proceeding, the court may from time to time pass such interim orders and make such provisions. So such word indicates, and such provisions indicate that whatever is the education consistently with the wishes of the child can be put forth. I'm sure an interim application under section 26 before the family court in a proceeding under the act, a parenting plan can be looked into. Now, how far this is effective, that depends on how you urge the before the court, what judgments do you present before the court. So there is definitely a margin for doing so, and there is a provision for doing so, and such an application can be made, and such a parenting plan can be evolved. This is the first question. Now, your second question, if I understand correctly, is can recorded conversations during meetings with the child be produced as evidence?
Yes, sir.
Is this
Yes, sir. That recording between husband and wife, family courts are disallowing that in Punjab and Haryana,
you
especially
see
quoting that judgment Neha and Vibhor,
you see
which is already pending before Supreme Court, sir, and there is stay on
yes,
that.
let us see. Suppose you are installing a recording device in the privacy of your bedroom and producing those outside in a court. It is an invasion of your right to privacy. If Supreme Court is looking into the matter and there is no clear or authentic view or pronouncement, producing such evidence will be disallowed by the court in the absence of a clear verdict from the Supreme Court. You must understand that there is a 12-judge constitution bench judgment in Puttu Swami's case on the right of privacy. So once there is a constitutional mandate which is so strong in terms of right of privacy and a right to be forgotten, which Shyam has also forgotten, uh, in that circumstance, uh, uh, not allowing private recorded conversations in the bedroom to be reflected as evidence.
No, sir. Please, may I interrupt you, sir? May I interrupt you, sir?
Yes.
Actually, sir, in many cases, these recordings are just between husband and wife, like call recording. They are call recording and they are not bedroom recording.
See, if
Even
it is,
then,
just a moment, if it is done with the consent of the other person, it can be produced. But if you are recording secretly without the other spouse knowing that you are recording, it cannot be produced. That is the way the broad legal principles of the court look at it. If it is,
okay,
if some person is told, I'm recording it, and you are being made aware of your rights, then that is can be produced. But if you are recording secretly, it cannot be produced.
okay. Thank you, sir. Thank you so much.
Rahul has also put the hand up. Rahul,
There
can
is
you unmute?
Rahul
Yes, sir. Am
and
I audible?
Vikas also.
Yeah, please.
Yeah. Am I audible?
Yes, yes.
Sir, I have two questions first. The first thing is that we say, as per Section 17 of the Guardians Involved Act, that the wishes of the child may be taken and they may be considered if the child is intelligent enough. So, is this superseding all the evidences on record? Does this supersede the cross examinations on record? Does this supersede the psychologist reports? And is there any judgment from the Supreme Court which limits the number of visits the child is to make to the court? If the child is made at least 20, 24, 25 visits to the court, no child will be in a condition to give his opinion to the court. It is a pure harassment of a child. It is against human rights. But with the change of rosters, with the change of family courts, then to the High Court and Supreme Court, child is called, and ultimately one day he gives up. And then he says that whatever you want to extract from me, you want to extract, I want to live with the mother. Okay, ji. You want to extract, I want to live with the father. Okay, ji. You want me to go to hostel. Okay, ji. Is there a judgment in the respect, sir, that
Yeah. So
beyond
I,
5 6
I'll answer your question straight away. You see, the view of the child is one consideration. Let's read the provision again. If the minor is old enough to form an intelligent preference, the court may consider that preference. The word used is may, it's not shall. So it is up to the court to decide whether this is an intelligent view, whether this is a balanced view, whether this is a normal view, or whether this is a view out of disgust. So there is no hard and fast rule. Some judges like to talk to children. Some judges say, I don't want to talk to a child because I'm not an expert, which is also, I think, very fair. And some judges abhor bringing children to court. They straight away pounce on a party and say, why have you brought the child to court? Did I ask you? So this is a very sensitive matter. And I agree with you. Asking a child to be brought to a court multiple times with change of roster or asking questions again and again will lead the child to say, to hell with you. I don't want to live with anybody. Just let me go. So there is a research project on the by Marilyn Freeman on the voice of the child in the abduction proceedings, and there is a project report. They say the wishes of the child is not akin to deciding on a fine on a parking ticket. This is not bringing the child to a court is not the child should not be made to feel that he has committed something wrong. He's made to commit certain offense. I think the only time the child should be called is once, maybe twice. A sensitive judge will take every precaution and care of calling the child to his chamber, giving him some sweets, giving him an ice cream, making him comfortable, talking to him, and in the course of normal conversation, very aptly finding out. Then the other way the courts have started doing is that the courts have asked renowned government hospitals where there are child psychologists or experts to talk to a child, maybe on Zoom or maybe on a visit, and finding out what is the view of the child. If you read Vivek Singh versus Romani Singh, Justice Sikri says a level playing field has not come. Child is very badly polarized. Unless the child comes back in a normal frame, we can't decide whether the child is to go. So, number one, the child's choice is only one preference. The court has to decide whether to pick the preference or not. The court has to be, you see, the court is the judicial scrutiny. The court has a judicial eye. The court has a judicial mind. The court is trained to look at the child, whether the child is polarized or unpolarized. Judges can do it. And I perfectly agree with you. Child should not be brought to the court repeatedly. Maybe once, maybe twice, and that's it. And if the judge thinks the child is polarized, the child is influenced, obviously the cogent evidence, which is led by a process of law, weighs. But again, you must not forget that the court has flexibility under the Family Courts Act. So this is the judicial eye of the court to decide what is right, what is wrong, what is the welfare of the child. Can I put the family together by the cogent evidence, or should I pick up the best interest of the child? So there is flexibility. There is no rigidity in the Family Courts Act. There is no hard and fast rule. It is a ascertainment and adjudication, assessment to be done by the court in its wisdom. I think that could answer your question.
So my question, another connected to that was that in a case where the child is given such opinions because of so frequent visits that sometimes he said he wants to live with the father, sometimes he said he wants his parents to reconcile together, sometimes he said he wants to live with the mother. The High Court, not even the Family Court, educated on the basis of that the versions which were in the favor of the mother be taken into consideration, and the child been uprooted at 15 and forcefully sent to the mother. Now, we have put on record the psychologist reports as well as the other versions. But surprisingly, the psychologist report has been sidelined, saying that they are private witnesses. However, they were not private witnesses. They were appointed by the family courts at various points of time. So how fair is that in law to pick and choose to favor one particular gender, which has certainly ruined the life of a 15-year-old teenager?
You see, this has to be decided on a platform in an appeal. You must realize that there is only one appeal under the Family Courts Act from a final judgment or an order against the order of the Family Court. And that appeal lies to the High Court, and that goes to 2 judges. So that is your best platform to say that this evidence is bad, should not be considered. This evidence is good, this should have been considered. And you have to leave it to the finality of the court. If you have something extraneous to say which has gone wrong, then the Supreme Court can look into facts. But once there is a concurrent finding of fact by the family court and the High Court, the margin for the Supreme Court to interfere on a finding of fact, dehors a finding of law, is going to be very difficult. So you have to be extremely careful, and you may go back and review to the High Court and say you have ignored this evidence. This is a ground for a review. Please reconsider this evidence. But if to counter the evidence of what you are saying, there is enough to the High Court to prove that the decision of the court is right, then you may not survive. It is a determination on the facts of a case. There can be no hard and fast rule, and every case has to be decided on the facts and circumstances of the case.
Is there any judgment
Sir,
of
we
justice?
have Saurabh Basi with another question. Saurabh, please.
Hello.
Yes, Saurabh.
Good evening, sir.
Yes,
Very namaskar to all the members and to the learned personalities as well as Anil sir. I have visited him not many times when I was in trouble. But the latest question which I am posing is that I reached a settlement with my wife in the Supreme Court Mediation Center, whereby I agreed to give the custody of my child to my wife, since she was having the custody from 2 or 3 years when she left the matrimonial home and never returned back. And it was in the transfer petition that we settled the issue, and the daughter was given custody. And the custody of the daughter was given for 4 days in 2 months. Now the daughter has started visiting me, and it was the second time that yesterday I had to leave her. And she visited her grandparents to her family home, whereby she is asserting that she never wants to go back to the mother and she wants to stay back with me. I just want to know that whereby I have already signed a pact with my wife that she will be having the custody. But on the other way, she has clearly on WhatsApp also, video calls also clarified this thing to her mother that she never wants to come back. Though I have returned today, I was bound to return the child today to my wife. I have returned the child to my wife. But I am very much upset that I am not able to fulfill her lawful demand, the lawful right to be loved and cared by the whole of the family, grandparents, a conducive environment. And this is my question: what can be done in my case, sir?
You see, Saurabh, I think
she is 6.5 years old.
Right. So, Saurabh, first of all, let me assure you what you have done is the right thing. As officers of the court, Sham and I will be unanimous to say that you have to respect the wishes of the court and you have to stand by an undertaking you have made as a gentleman. You have to leave it to the wisdom of the system. I can imagine you are upset. I can imagine she's upset. I can imagine the emotional outbreak, the bonding, the sufferings. But you must let the child understand that the child has to share both of you. Let the child find a way with the mother and say, why can't you both, my father and mother, get together? If the child goes back to the mother and says, I want to be with the father, I want to be with you, just both of you together. And I think you can go back to the mediator. You may not have gone back to the court. Have you gone back to the court and has the mediator's agreement been finalized?
Actually, it was in the mediation center before the Supreme Court that she allowed the...
No, but has the mediators
were there.
Has it gone?
Settlement was there. We have divorced, sir.
You have divorced. So has the family court disposed of your transfer petition?
That was disposed of by the Honorable Supreme Court only. That it was in the Supreme Court. My wife preferred a transfer petition in the Supreme Court seeking transfer of the Section 9 case which I instituted at Punjab.
Let me tell you one thing. Child rights are never final. there are judgments which clearly say, there is a judgment by Justice Gokul Mudgul in Delhi in the Delhi High Court, where he very clearly says there are judgments of the Supreme Court also you can find. Child rights are never final. You can reopen the matter in a fresh petition. There may be opposition that this is res judicata, but there is no res judicata in family court decisions of child custody, because they are never final. Children's needs keep evolving, they keep changing. Child may express differently after some time. Child may say differently. The child may want to go back to the mother. So there is no hard and fast rule that the judgment is final for all times to come. You can reopen the matter, but you have to be careful that you have the material and you have the evidence. So don't feel bad. You should feel happy and proud that you were able to honor the decision, and that will inspire confidence in the system that this is a man or this is a parent who abided by the decision of the court, and therefore this man's perspective or the child's perspective must be relooked at. So you may have lost now, but you have gained and you have won in the longer run. Don't feel bad. You've been coming to me, I know, but still, I think you have taken the right decision. You have acted. I did not prompt you to act intentionally. So I wanted you to take your own decision. You have taken the right decision. You are a lawyer yourself. So please go on the right path. And there are platforms like this, which Littles has evolved with justice, which Jam and honorable judges have evolved. This is where we can share these things with you. So don't feel bad. Don't get emotional. Stick to the system of law. Respect it. The system will give it back to you what you have put in the system. Right, Sham?
Thank you.
Right.
And
Thank you. Thank you very much. Highly.
thank you very much. And over to you, Prem.
Well, that was a very interesting topic.
It is
that we had today.
It is better than your Big Brother business.
And as we all know,
very emotional today.
Yeah, because the law governing this custody of a minor, that has, we all know it is closely linked to this guardianship. You have a bunch of rights, you have a bunch of obligations, powers that any parents would have vis-a-vis the person and property of that minor. And a very significant facet of this right is that guardianship. That is why the guardianship or the custody orders that never attain permanence or finality, because it can be questioned at any time by any person who is genuinely concerned about the minor's welfare. As we see in Justice Vikramjit Sen's judgment of 2015, many judgments are there, and that has been already spoken to by Anil Malhotra sir. We have statutes like the Guardian and Wards Act. You have the Hindu Marriage Act, Section 26. You have the Hindu Minority and Guardianship Act. And of course, the Divorce Act, Section 41. Section 38 of the Special Marriage Act. You have the Parsi Marriage and Divorce Act. There were so many statutes. And all these statutes would say that it is ultimately the welfare of the child which is of paramount consideration. And quite interestingly, in one or two of the judgments of the Apex Court, Saraswati Bhai Ved's case is AR 1941 Bombay decision by Sir John Beaumont, wherein he had the occasion to hold that it is not the welfare either of the father nor that of the mother that is for paramount consideration. It is only the welfare of the minor and the minor alone which is of paramount consideration. And as you pointed out, Justice Ajay Rastogi's that Lahari Shakamuri 2019 judgment, that really has beautifully portrayed the whole concept. Kindly see, there is a beautiful paragraph therein which would observe that the divorce and the custody battles that can become a quagmire, and it is really heart-wrenching to see the innocent child who is made to suffer ultimately, who gets entangled or enmeshed in this legal and psychological battle between the parents. And the even full agreement about the minor's custody, that often would be a reflection of the parents' interest rather than that of the child's. Because here the child's psychological balance is deeply affected. through this marital disruption. And of course, sir, as you said, that section 17 of the Guardian and Wards Act, clause 3, it merely says that if the minor is old enough to form an intelligent preference, court may consider that preference. Now, this is because such orders, as I already told, such orders regarding this custody, they are capable of being altered and molded, keeping in the mind the needs of the child. That has to be read in clause 3 again. Because while we are deciding, or the courts are deciding a very difficult or a complex question regarding the custody of a minor, as we see, the court has to keep in mind not only the relevant statutes, the rights flowing therefrom, and cases cannot be merely decided solely by interpreting all these legal provisions, because this is a human problem which is required to be solved with human touch. And in custody cases, the court is not bound either by the statute or by the strict rules of evidence or the procedure or by any precedents, because here you are exercising the parent's patriae jurisdiction. The court is bound to give due weight to the child's ordinary comfort, the child's contentment, the education, its health, intellectual development, everything, all the favorable surroundings, and over above all these physical comforts, the moral and ethical values, they cannot be ignored. And sir, I have come across a judgment, a recent judgment in Smriti Madan's case, 2020 SEC. It's a 3-judge bench decision, with Justice Anil Malhotra spoke for the majority. So you might have read the judgment. The mother, she herself was a lawyer, got married to a Kenyan citizen who holds a UK citizenship as well, and they had a son. The Delhi High Court, after having interacted with that minor, who was at that particular point of time, he was 6.5 years. By the time it reaches the Supreme Court, he was 11.5. The Delhi High Court observed, after a very long conversation with the child, that the judges were so deeply impressed with the maturity of this intelligent 6.5 years old child. And they went on to say that he displayed self-confidence and had a very remarkable capacity of expressing himself with absolute clarity, exhibiting absolutely no sign of confusion or nervousness. Now, Justice Indu Malhotra took note of the entire circumstances, and of course, she ordered for custody. But was this by itself a sufficient for deciding the custody? Now, to decide the issue of best interest of the child, the court would take into consideration various other factors as well, not merely on this. Not merely on this. Now, the dissenting judgment by Justice Hemant Gupta, this beautiful dissent. Justice Hemant Gupta, who dissents, he held that though the child was intelligent, the child was not mature enough to take a decision by himself. Because even the law would recognize that the child of less than 18 years is incapable of representing himself. So, the opinion of the child is not a determinative factor in the final custody of the child, because the court was acting in the parent's patriae jurisdiction. It was bound to assess the entire situation and enter into a finding whether the welfare of the child, that either would be with the mother with the visitation rights to the father or vice versa. Of course, true, sir. If a ward is capable enough of forming an intelligible opinion, and the ward is able to express his views independently, that also has to be taken into consideration in reaching a conclusion. But an additional circumstance, as you told, that has to be taken into account in seeing whether the minor is in a position to make an independent preference. If the minor was with the father, the chances that the minor would speak against its mother are too high, and vice versa. Now, we need to remember that the child is going through a very vulnerable time at that particular point. So that preference of the child, instead of being intelligible, it may not be independent. It may be artificial, even though it may look intelligent. So the minor's preference need not necessarily be decisive. That can be one of the factors to be taken into consideration, provided that the court is satisfied that the minor is capable of forming an independent and intelligent preference. So I think the word independent also has to be there, even though it's not in the section. So thank you, sir, for that wonderful talk. Thank you so much.
Prem, I need to update you on something. I agree with you what you have just said. First of all, in 17.3 says the court may consider.
Yes,
It's not
yes, sir. May.
that's
Absolutely true. The
now,
difference
now,
between may and shall absolutely true.
now what you say is finding clear evidence that Justice Hemant Gupta's dissenting view reflects back, because let me share with you what happened in Perry Consagra. First of all, Perry Consagra has two judgments. One
Correct.
is of
Three judgments, sir.
three judgments. One, the initial one was on whether the report of the mediator can be made known to the parties, and the Justice Lalit has interpreted to say, following an earlier judgment, that the best interest and welfare of the child determined must be made known to the parties. Then Perry Mon Consagra reported in 2020, volume 12, scale 450 and 788.
Correct. That's
This,
the decision I was referring to.
according to this judgment, there was a mirror order made in Kenya, whereby the Supreme Court's order was mirrored in Kenya, and Perry Consagra was allowed to take the child to Uganda. But when he took the child to Uganda, he refused to return the child. Contempt notice was issued to him. He refused again. So he was held to be in contempt, and the money deposited, I think 50 lakhs, was given to the lawyer, and the judgment has been recalled. So Perry Mon Consagra is no more good law. Only Navteej Singh holds, because Navteej Singh, there was nothing like that, and the lady had to go back. So because the reciprocity was not honored, this has gone. And the second aspect of which you're talking about is very well laid out in Vivek Singh versus Romani Singh, Parental Alienation, 2017, 3 SCC 231, wherein 13 and 20, they talk of welfare. In paras 18 and 20, they talk of parental alienation syndrome. Justice Sikri says, I am not going to decide this. I find the child is very badly alienated. Whatever it is, the wish of the child is not normal. He's polarized. He is alienated. I am not going to take a call on custody. So what you are saying is very, very true. Is the child deciding under stress? Is the child deciding or saying just to be with a better parent whom he thinks is better, but actually is not better? But I think this is judicial wisdom. The court has to use its microscope, judicial microscope, to see whether it is the best interest or whether it is not the best interest. Whether, as the gentleman previously said, if there is cogent evidence to the contrary, should the best interest of the child be considered? I think the judge has to balance it out. But all the same, beautiful concept, beautiful points noted, finer threads, not just the best interest of the child, but cogent evidence as well.
Correct.
Thank you.
Shyam is getting bored now.
No, it's not. I mean, questions are coming again. So I'm just requesting. I left the number of Anil Malhotra sir here. Kindly.
And with regard to that Vikas question, second question, whether a recording, he was saying of a stay order from the Supreme Court. Stay order does not wipe out the order. See, there is ample difference between stay and quashing. Stay is only regarding that particular order, staying the operation of that order. It does not operate, because if it is, of course, if it was one challenging a statute, and it is a stay, because all of us know that there's a division bench ruling of the High Court which says that the CBI, it is not a legal entity. 5 years back, the matter was stayed by the Supreme Court, but still, doesn't the CBI investigate cases? And he was asking whether a video which is recorded or an audio which is recorded, whether that can form part of the evidence. Of course, sir, Puttuswamy is another thing to say. But still, sir, the legal proposition is that if a document is procured either by improper or illegal means, there cannot be a bar to the admissibility if it is relevant and its genuineness is proved. If the evidence is admissible, it does not matter how it has been obtained. Of course, as a matter of caution, the courts, in exercise of its discretion, of course, can disallow certain evidence in matrimonial disputes also, because strict rules of admissibility cannot operate. We have Section 14 of the Family Courts Act. Again, so the court has to conclude that it is genuine, it is free from tampering, or it is free from being mutilated. Because the Supreme Court in many cases, the Supreme Court, even post this Puttaswamy, as well as pre-2017, the contention that obtaining evidence illegally by either using photographs or by using tape recorders can never offend Articles 20, Clause 3 or 21. Because acquiring the evidence by such methods, because it was contended that acquisition of evidence that was not in accordance with the procedure established by law. But this contention was totally repelled, right from Yusuf Ali Ismail Nagri's case of 1968. We saw that in Afzal Guru's case. You had in Aram Malkani's case. There were so many cases. And of course, Puttaswamy judgment, as you rightly said, that of course explains the scope of the right to privacy on admissibility of evidence. But I would say that Puttaswamy never had taken a drive on a different lane, because even Puttaswamy goes on to hold that right to privacy is not an absolute right. It's not an absolute right. And definitely cannot be like by putting one person's personal liberty and choice at stake, of course, because obtaining evidence and proving it in a court of law, that is, on one hand, it is very important aspect of law, and through collecting them at the cost of somebody's privacy, especially as Vikas has asked, when it comes to this phone tapping or whatever, that it can culminate in injustice. But the courts have to balance. That's my take on that. Of course, subject to correction, sir.
Thank you, Prem. I think we can defer Vikas and Rahul's question. I shared the number of Anil Malhotra, sir. Why? Because it's already, it's almost reaching 7 o'clock now.
Oh.
So as we come to the end of the 284th session, a special thanks to Anil Malhotra, sir, for, like you said, sir, it's a very, very sensitive topic and something,
and Shyamana, before concluding,
yes,
sir, you had put the next topic in the group. Our next topic. Shared wives. And Mr. Ravu was asking whether it is to educate
or it is to propagate.
Not propagate.
Instigate, maybe, sir.
See, there is a, I read a quip on a case reported by Law Trend, where a man was seeking custody of his girlfriend from her husband. So the High Court has dismissed his petition with 5,000
rupees cost. Correct, sir.
Yeah. So that is a topic which will be led by Justice Ram Kumar to fine him for his presence.
So, sir, let us say goodbye for the night, and very special thanks to you and also to Justice Ramashan, sir, and all of you wonderful participants. Let us meet again next time with another topic, and let us have more interaction. Thank you very much, sir. Till we meet again. Do take care and stay safe.
Benefit of Vikas or the other gentleman, Leeladhar Kachru versus Umang Kachru, 2005 2 HLR 449 is the judgment which says that child rights are never definitive. All the best. Thanks a lot. Goodbye. Good day.
Thank you, sir.
Thank you.